Hello friends, today we will discuss section 56 and section 57 of the Indian Evidence Act. Section 56, I am reading the section. Read with me. Fact judicially noticeable need not be proved. No fact of which court will take judicial notice need be proved. Let us understand this section through some interesting case laws. The first case law is on your screen. Supreme Court observed in Rajkumari versus Devraj in the year 1977 that certain notorious facts exists which need not be proved. Formal evidence of a notorious fact is not necessary. This observation was taken by the Honorable Supreme Court in the year 1977. The next one. The next one is on your screen. A judge is entitled to use his knowledge of general or public facts, historical, scientific, political, or otherwise. He is entitled to take judicial notice of matters which have reached the court. He is also entitled to take judicial notice of matters which have reached the court. He is also entitled to take judicial notice of proceedings in the assembly, not of the truth of the fact asserted in the speeches, but of the fact that such speeches were made. Judge is not entitled to consider whether the fact of the speech is truth or not, but judge can take it into his judicial notice that such speech was given in the assembly. Judge can take judicial notice of any matter that has reached the court of any chaos. Say we are sitting in Delhi High Court and in Connaught Place there is some huge chaos, and that information, that effect came up to the Delhi High Court. So a judge sitting in Delhi High Court can take judicial notice of it. The next slide is on your screen. We cannot shut our eyes on the stark realities. From the National Crime Records Bureau, it is clear that close to 2 lakh farmers committed suicide in India between 1997 and 2008. This data is available in National Crime Records Bureau. We cannot shut our eyes from the hard fact, from the realities. This is the largest sustained wave of suicide ever recorded in human history. 2/3 of the 2 lakh suicides took place in 5 states. And those 5 states are Maharashtra, Andhra Pradesh, Karnataka, Madhya Pradesh, and Chhattisgarh. Even though Maharashtra is one of the richest states in our country and it is the capital, in its capital Mumbai, 25,000 of India's $1 lakh millionaires reside. The Vidarbha region of Maharashtra, in which is situated Bulwanda, is today the worst place in the whole country for farmers. Professor K. Nagraj in Madras Institute of Development Studies, who carried on a research in this area, has categorized that Maharashtra could be called the graveyard of farmers. This observation was taken by the Honorable Supreme Court, and Supreme Court observed that court cannot shut its eyes on the hard facts, hard realities, and this thing can be taken into judicial notice. Now I'm coming to the next section, section 57 of the Indian Evidence Act. Facts of which court must take judicial notice. Here the word must has been added. The court shall take judicial notice of the following facts. Number 1, all laws in force in the territory of India. Within India, in India, all acts enacted by Parliament or State Assembly, all acts should be taken into judicial notice. All public acts passed or hereafter to be passed by the Parliament of the United Kingdom and all local and personal acts directed by Parliament of the United Kingdom to be judicially noticed. Articles of war for the Indian Army, Navy or Air Force. The course of proceeding of Parliament of the United Kingdom, of the Constituent Assembly of India, of Parliament and of the legislatures established under any laws for the time being in force in a province or in the states. Any acts of Parliament must be taken into judicial notice. The accession and the sign manual of the sovereign for the time being of the United Kingdom of Great Britain and Ireland. The seal of which English courts take judicial notice. The seals of all the courts in India and of all courts out of India is established by the authority of the central government or the crown representative. The seals of courts of admiralty and maritime jurisdiction and of notaries public, and all seals which any person is authorized to use by the Constitution or an Act of Parliament of the United Kingdom or an act or regulation having force of the law in India. So any seal of any statutory body, notary public, any court within India or outside India should be taken into judicial notice. The accession to office, names, titles, functions and signatures of the persons filling for the time being any public office in any state, if the fact of their appointment to such office is notified in any official gazette, if it is published in any official gazette. The existence, title and national flag of every state or sovereign recognized by Government of India. The national flag of every country which has been recognized by the Government of India must be taken into judicial notice. The divisions of time, geographical divisions of the world, GMT, time division, and the public festivals, Bengalis Durga Puja, all over India, Diwali, Holi, in Christian community or in Christian countries, the Christmas, the divisions of time, the geographical divisions of the world and the public festivals, fasts, Roza for the Muslims, and holidays notified in the official gazette, and other holidays which were notified in any official gazette. The territories under the dominion of the Government of India, the commencement, continuance and termination of hostilities between the Government of India and any other state or body of persons. The names of the members and officers of the court, names of the members and officers of the court, who is the Chief Judicial Magistrate in Alipur Court as on date, the name of the person must be taken in judicial notice. The names of the member and officers of the court and of their deputies, the subordinate officers and assistants, and also all officers acting in execution of its process. The other bench clerks, head clerk, Nazir, everyone, and of all advocates, attorneys, proctors, vakils, pleaders, and other persons authorized by law to appear or act before it. So two parts. One part, the officers of the court and their subordinate officers and their subordinate staffs. And number two, the lawyers and others who are by act are entitled to appear before it. Before it means the court. The rule of the road on land or at sea. Rule of road or on land or at sea. In all these cases, and also on all matters of public history, literature, science or art, the court may resort for its aid to appropriate books or documents of reference. In case of necessity, court may refer to appropriate book or documents for this purpose. If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so. The last para is very much important. I am reading again. If the court is called upon by any person to take judicial notice of any fact, say I am plaintiff in a particular case and I want that the court must take judicial notice of a certain fact. Court may refuse to do so unless and until such person, that means the person who is asking the court to take judicial notice, unless and until such person produces any such book or document as it may consider necessary to enable it to do so. For taking into judicial notice, the person who is asking the court to take a certain fact into its judicial notice must have to produce the book or document in this regard. Before concluding, I think few very interesting case laws I should mention here. Otherwise, the entire episode will remain incomplete. The slide is on your screen. Matters on which court can take judicial notice. First, court can take judicial notice of notorious facts. It was decided by Allahabad High Court in Abida Khatun versus State of UP case in the year 1963. So, in any notorious facts, court can take judicial notice. Next, court can take judicial notice of matters with which men of ordinary intelligence, men of ordinary intelligence are acquainted and to act when his general knowledge or local affairs. It has been decided in the year 1978 by Patna High Court. Next, this one is very interesting. Occurrence took place at 7 a.m. in the month of April. Court can take judicial notice that it was not dark at 7 a.m. It was decided by the Delhi High Court in the year 1989. A registered power of attorney is admissible without proof. If I produce a registered power of attorney in connection with any case, it will be taken into judicial notice without any proof. Drought in a part of the country can be taken in judicial notice. Say I am sitting in Kolkata court, in any of the Kolkata courts, and there was a drought in Kerala. Court in Kolkata may take into its judicial notice, should take its judicial notice on that particular drought. Next, the court can take in judicial notice the practice prevailing in stock exchange. How the transaction in stock exchange takes place. Court can take all these things into judicial notice. This was decided by the Honorable Supreme Court in the year 2006, very current judgment. So, today I discussed section 56 and section 57 in this very short video. In my next episode, I will start from section 58. Till then, I will request you to share this video if you think that this video episode will be helpful for the junior lawyers and the law students. Thank you for watching this video. Stay blessed.